Hello, I'm Claire Young, George Brown College business student. The purpose of this video is to provide an overview of all relevant information regarding the transfer of a Canadian employee from a Canadian multinational enterprise to a U.S. subsidiary of that company, along with a spouse/partner of the Canadian employee. The video will go over the different visa options that are available for Canadians working in the U.S. It will also go into more detail on the L1 visa, since this is the most applicable to the simple situation in question. It will also go into the requirements, the skill requirements for obtaining that visa, the costs surrounding obtaining that visa, the documentation that is required to obtain it, time limits surrounding that visa, and finally we'll talk about how the spouse's life would look following the Canadian employee to their placement in the U.S. subsidiary. WorkPermits.com describes the U.S. visa system as probably the most complex in the world. Research identifies several different visa options for Canadians going to work in the U.S., and some of them are only applicable to quite specific situations and scenarios, so we will not go into detail on all of them in today's video. I will, however, briefly run through a fair few of the options that are available. A Canadian doing business in the U.S. might be an E2 treaty investor, which is someone who has made a significant investment in a U.S. business, leading to at least 50% ownership of that business. They may also be an E2 treaty trader, which is someone who conducts a substantial amount of trade with the U.S., between the U.S. and Canada. H-1B visas are for workers traveling to the U.S. to fill a temporary shortage in a certain sector. This could be a seasonal shortage, but the sector in question excludes the agricultural sector. There are also J-1 visas, which are for those participating in a recognized exchange visitor program. Then there are TN1 visas, which are similar to H-1B visas, but they make it a little bit easier for Canadian and Mexican citizens to achieve a specialist level. And there are also O-level visas, which are for individuals of extraordinary achievement. So that's a very specialized situation, so today we will be focusing on the L1 visa, which is the most applicable for the simple situation of a Canadian citizen from a Canadian multinational enterprise going to work in a U.S. subsidiary. So let's go on that journey with that employee today. The L1 visa is a temporary non-immigrant work visa, which is described by ViejaImmigration.com as designed for Canadian workers wishing to be transferred full-time or part-time to the United States to work for a U.S. subsidiary of their Canadian employer. The following are the requirements for obtaining an L1 visa. 1 year of uninterrupted full-time employment with the Canadian company within the last 3 years leading up to the application for the L1 visa. Having managerial or executive functions within the company, or having functions requiring specialized knowledge. Having thorough knowledge of the company, including all of its procedures and processes. Having a U.S. position that also has managerial or executive functions or that requires specialized knowledge. And finally, both the American and the Canadian subsidiaries that are participating in the transfer must continue to do business in their own separate countries. In response to a frequently asked question about L1 visas, the company that is doing the transfer and participating in the transfer is not required to pay the employee the prevailing wage or any certain wage level. However, companies that do pay the employee less than the prevailing wage may have their applications for the L1 visa viewed unfavorably. L1 visas are actually classified into two different types. There is the L1A visa, which is for workers traveling to the U.S. for their managerial or executive functions, and there is the L1B visa, which is for those traveling to the U.S. for their specialized knowledge. One thing that I'm sure you will be happy to hear about the L1 visa is that the vast majority of the fees associated with obtaining it are the responsibility of the employer, not the employee. In fact, the beneficiary is not legally permitted to be the one to pay those fees. And if it is found that the employee, not the employer, is paying the fees for obtaining the visa, the company could be in for some very serious legal consequences. That being said, however, obtaining an L1 visa is not cheap. The fees are as follows. So the fees that are the employer's responsibility: $460 for a basic filing fee, $500 for a fraud protection and detection fee. This money is to help the United States Citizen and Immigration Services to detect and deal with anyone who might be attempting to commit fraud through an L1 application. $4,500 for the Public Law 113-114 fee. This is only applicable in certain circumstances. That is to be paid by employers who have more than 50 employees working in the United States and who have at least half of their employees under L1 or HB1 visa status. There are also attorney fees, which vary and are optional but are highly recommended by reputable sources. One reputable source that was consulted in the making of this video charged a $4,000 flat fee for attorney services. Then there are optional fees such as premium processing. Premium processing is a service which expedites the L1 application process, bringing it down from a time period of 2 to 4 months to a time period of 15 calendar days. That is $1,225 of a cost. And finally, the only fee that is for the employee to pay is the non-immigrant visa fee, which is $190 and is to be paid at the U.S. consulate or embassy. It is important to note about the premium processing fee in the L1 fees that this fee could either be the responsibility of the employer or the employee. Either one could pay it, does not matter. However, the United States Citizenship and Immigration Services will require documentation that you were not coerced to pay that fee if you individually are the one who pays it. Otherwise, the company in question could be in for some serious consequences again. IMMYHelp.com contains a comprehensive list of all the documents required to obtain an L1 visa, and that includes all present and past passports of the applicant, one photograph, a confirmation page of the online submitted form DS-160, the original interview appointment letter and copy, an I-129 petition receipt number, a letter from the prospective employee's employer abroad confirming the dates of their employment, the job duties, the qualifications, and their salary, all relevant work experience, diplomas, degrees, certificates, etc. of the applicant, the name and contact information for at least 2 managers and at least 2 co-workers at the present and past positions of the applicant, the personal bank statements of the applicant for the past 6 months, and a CV. A white stamped I-94 card is the final visual representation of the applicant's acceptance and their validity to work in the United States, and this is obtained, actually stamped in the passport of the employee at the U.S. port of entry where they enter the country. And that is only after they have presented all of the required documents for the L1. So now on to what you will get from giving all of this to get the L1. The L1 is valid for an initial period of 3 years for existing U.S. companies. For new U.S. companies, the visa is valid only for 1 year. L1 visas are extendable in increments of 2 years. The L1A visa extendable up to 7 years total, including those 2-year extensions, and the L1B visa extendable up to 5 years total. L1 visa holders are allowed to bring their spouses and unmarried children under the age of 21 years with them to the United States under an L2 classification. L1 visa spouses under the L2 classification can obtain a general work authorization and work in the United States. L1 children under the L2 classification are, however, not allowed to work in the United States, but they can study. The amount of time that L2 dependent spouses and children are allowed to stay in the United States is the same period of time as the L1 holder they are associated with. At this current point in time, there are no provisions for same-sex spouses or common law spouses under the L1 visa.